Good afternoon, colleagues. Apparently, apologies for a slight delay. We were just in the backstage area and had forgotten to click the button to get us into the meeting this afternoon. So our apologies for that. Just to introduce myself, my name is Paul Watkins, and I'm a national negotiating official with the NASUWT, and we've also got my colleague Anne Brimacombe, who is also a national negotiating official for the NASUWT, and we are here today to talk to you a little bit about negotiating and consulting on policies, the process that's involved, little tips and hints and what to look out for, to hopefully equip you, if you're not already equipped, with the tools you need to go back and make sure that you're doing this in the correct manner, I suppose. Not to say that you aren't already, by the way. So it's just a few tips and hints about how to do that. Now, hopefully we will have time for some questions. If you have got questions, please try and put them in the Q&A box rather than the chat, because often what happens in my experience is people start to say hello to each other in the chat, and you then got to sift through all of that in terms of getting to the questions that people may have. So hopefully we'll have time for questions. So without further ado, we will crack on. So we're here to talk to you about negotiating and consulting on policies. Next slide, please, Anne. Thank you. So as said earlier on, the aim of this is to explore the key points around it, around consulting and negotiating on policies, and to provide some guidance, advice and guidance on this when looking at key elements of disciplinary policy. So I'll handle the first half of the session, looking at the idea of consulting, negotiating, and then my colleague Anne will take over and put some of this into practice in terms of when looking at a disciplinary policy, what you would be looking for, and advice and guidance around that. So when you look at consulting or negotiating on a policy, this will depend on your background, your experience. Some of you may already be very experienced in doing this. Some of you may be relatively new to doing this. So we've got a number of what you might describe as important considerations. So things that are important to try to understand before you enter into consulting and negotiating on policies. And we'll go through these in a bit more detail. So one of them is the use of the TURA, and the TURA stands for Trade Union Recognition Agreement. So the use of a Trade Union Recognition Agreement, does one exist? Can you locate it? If one doesn't, do you have to go through the process of doing that? Previous policies and no detriment. So we'll talk a little bit more about that in detail. Policy consultation with an employer or with the employer. Consultation versus negotiation, because those two words are very important, but they're very different meanings in terms of how we operate, but also in terms of the law as well. Timescales and how you might describe meaningful consultation, and obviously issues where there may be a failure to agree. So obviously, in the background to a lot of what you might be doing is the Trade Union Recognition Agreement. So the Trade Union Recognition Agreement, you may already have one that's established, and that will obviously give you a background and understanding of how you move forwards, because it should provide for the overarching or the overriding architecture for effective engagement with the employer and the basis for good industrial relations. So you should have a recognition agreement. And if there is a recognition agreement, it does provide for how things happen, what takes place, how they operate. So it should contain within it the details of what's in scope, what's out of scope, and it should also provide a mechanism for the process to take place. Now, there is a TUC model recognition agreement for academies if you're working in an academy. And obviously you can find that on the TUC's website. I'm pretty sure it's probably on our website, but it's a standard agreement agreed with us and other trade unions about what a trade union recognition agreement should look like. And when you engage with different employers, most employers tend to understand that, most employers tend to appreciate that, and most employers adopt the vast majority of the provisions in the TUC model agreement. The TUC model agreement does, as we're discussing later on, reference consultation and negotiation. But if you may also have a local collective agreement with your local authority, identifying how you do things, which has been negotiated between the authority and the NASUWT. It is important when you talk about recognition, and some of you may have had the experience of transferring from one employer to another. For example, if it's a local authority maintained school and it goes and becomes an academy, then obviously those things transfer over. The recognition transfers over. So the employer has not de-recognized the union. In fact, there is a very arduous and very convoluted and lengthy process that the employer would have to go through to de-recognize a trade union. So it's quite a difficult thing for them to do. But obviously, they may conveniently use this as an opportunity to sort of say, well, we want to reconfigure and relook and examine again how we operate. But the recognition transfers over. So what might happen is there might be a need to establish an appropriate mechanism to operate, and the rules of engagement, or the rules of the game, as you might want to call them. So obviously that would then involve looking at that TUC model agreement and working within that constraint and looking at how you could work within that. A trade union recognition agreement, by the way, may already exist. And the Trade Union and Labour Relations Consolidation Act does set out the scope of what's meant by collective bargaining. It's section 178 of that particular legislation, and it establishes what's within scope for the purposes of collective bargaining. And that does quite clearly include terms and conditions of employment. So as you can appreciate, for us, terms of employment, we would define that as being quite broad, and we would want to capture quite a lot of stuff in that, because if it comes in scope, then we've got oversight of it. We can look at it. Next slide, please. Thank you, Anne. So when we get into consulting on policies with an employer or with the employer, then obviously there are what we call statutory policies, which by law they've got to have in place, and there are what are often referred to as non-statutory policies. And very important to bear in mind, that's not just from the perspective or view of the employer. We may take a different position on what is seen as statutory and not, and we would want to obviously assert our right that it is a statutory policy. So you've got your statutory policies. So you've got ACAS code around a grievance, a disciplinary. There is also if you work in academies, there's an academies handbook, which details the sort of policies they expect them to have. So you could also use that as a lever to argue that some of these policies are on a more statutory footing, perhaps potentially, because funding agreements are dictated by the rules of the Academy's handbook. So there's an argument if they're not playing by that, then obviously you can make the point, well, how does your funding get maintained? So the trade union recognition agreement as well may specify which policies fall within scope. So if you look at the TUC model, and I certainly with the employers I deal with, we've managed to secure in there policies around teaching and learning. So that then means within the TURA, we should be consulted upon when it comes to talking about, say, behaviour management policies, which often for our members can be quite a work-intensive thing and can have quite a positive or, when not done properly, detrimental impact. So, the TURA the TUC adopts is quite broad. And obviously, we might want to use that, and the churra may be broad in terms of what's in scope for consultation. So when you're talking about policy consultation with the employer, it's important to establish some protocols for policy consultation, particularly around the process and the timescales. That may vary depending on how many policies you're looking at. So recently, I was in discussions with a multi-academy trust I deal with, which has got 40-odd schools, and we were talking about trying to get a much better process because there had been some issues where they thought they'd done it appropriately. They were quite new in their role, and we, as the trade union side, were sort of saying to them, well, actually, this is how it should operate. And we discussed about timescales, and obviously we were saying, well, if it's one policy and it's not complicated or onerous, so it could potentially be, for example, a flexible working policy, then you could consult and go through that process relatively quickly. But if an employer sends you 4, 5, or maybe 6 policies, then it's not appropriate to have the same level of timescale. So that needs to be considered. I personally would say that a minimum is 4 weeks. I think 4 weeks allows a decent level of time for policy consultation. And it's important to bear in mind when you're doing that, that may be the first stage, because that may be when all the trade unions after 4 weeks submit comments on the policies. And then after that 4 weeks, the employer takes them away, and there'll be the opportunity for the employer to respond. And then that might take place electronically. So you are probably talking, it's longer than 4 weeks, but 4 weeks is the sort of starting point by which I would feel comfortable in terms of getting a policy from an employer, or a couple of policies, 3 or 4 maybe. Depends again on how long they are. I know my colleague Anne was saying she dealt with a disciplinary policy the other week, 64 pages. So it will depend. That could take 4 weeks in and of itself. So it's important to just bear in mind these are fluid, and you can push back with an employer who says, well, we've got to get this done. I've got 2 weeks. It's sometimes useful to say to the employer, well, when does it go to the board or the board of trustees or the governing body for ratification? Work back from there. So if you've got that meeting in 8 weeks' time, then that works. If you've got the meeting next week, it doesn't work. So you might have to delay putting that policy in front of the board of trustees or the governing body. So obviously receiving a policy, providing a response, and ensuring a written response is received from the employer. So it is important in terms of making sure you acknowledge, you send in your comments, and you say, this is on behalf of the NASUWT. It's very important that you probably ask them to acknowledge receipt of that. If you're a bit like me, I copy myself in, so I know there's evidence that I've sent it. And I always ask the employer, I say, we very much look forward to your detailed response to all of our comments as part of meaningful consultation. So you are making it clear you expect a response to all of them. Now, you may get a detailed response, you may get less detailed response, depending on what the comment is you've made and the length of that. I've put in here question mark, it may be necessary to have separate meetings. And certainly I do that with a number of employers now. We've got our normal meeting where we discuss, say, for example, what the trust is doing, if the trust has got any issues, if the trust is taking on board more schools or not, what's the general thoughts of the trust, finances. So you may find you're squeezed out with some time that you can carve out of that to discuss the policies. So you may say, well, let's have a policy meeting as well. Now, obviously, quite clearly, that does impose more workload, but I've always found that helpful. And I think from my perspective, I've sometimes always found policy meetings to be helpful if they're in person as well. I've certainly had experience in the virtual world of members on the opposite side, as it were, the employer not understanding what I'm saying. But when I've gone into a meeting with them, a physical meeting, it's far easier to get your view across, I believe. So that would be a discussion piece for you to have. Now, obviously, it may be the case that we work with others. And what I mean by that is, are we working with other trade unions to provide a collective response or collating responses? Some employers, and again, this goes back to the trade union recognition agreement with the Chura, talk about a staff side and their secretariats to it. So I happen to be the secretariat for a very large multi-academy trust, and the trust likes it if there's one voice. So putting together a collective response. Now that's different in some respects to collating responses. I also do that for some trusts as well, where essentially I get all the other trade unions to send me comments in. I put them onto one master document, and that goes over to the employer. So all the comments for all the trade unions are on one document, rather than the employer receiving one from us, one from the NEU, one from NASUWT, one from NHT, Unison, Unite, GMB, etc. So employers do sometimes push for a staff side secretariat and a staff side response. And I do think there's a note of caution there, because obviously we are a sovereign trade union. We're our own body. We're independent. We do our own thing. We're not part of a group. And sometimes groupthink doesn't equate to what we as a union would want. So you have to be careful about that. And I think there's a note of caution about, sometimes it works, and it works really well. I've got some employers where I work with other trade unions really well, and they will just agree with everything we've said. Sometimes it's a bit more confrontational, a bit more adversarial with other trade unions. So we stick to our own position because our position doesn't necessarily align with the position of some other unions. And I think, it's just one of those things where it's a little bit suck it and see, and another phrase, horses for courses. But just be careful about this staff side response, because I've had it come back to bite me where somebody said, well, the staff side said this. And I've sort of said, but that's the staff side, and it's taking the view of all the other unions. But in terms of the NASUWT, we don't actually agree with this because of X, Y, Z. So I think it's just important to that, because sometimes it can misrepresent what our position is. I think also as well, it's important to understand the process for agreeing a policy. And I've put a question mark there because in my experience, NASUWT, we have quite a high bar, quite a high hurdle to get over. So it is quite rare for us to agree a policy. I don't think I've agreed many policies in my time working for the NASUWT for 9+ years. That doesn't mean to say we are difficult or awkward. We just do have a high bar, and we want the policies to work for our members. So I think it's important to understand, is there a process? And I'm very, very clear with the employer that, if they haven't heard from me, because again, I've had this come back to bite me in the bum. I've seen words like approved or agreed, and I've had to then put the employer on notice to say, well, could you tell me when we agreed this policy? I want the evidence, because for me, you would know if I've agreed a policy because you get an email saying the NASUWT has consulted with members, has consulted with its executive members, etc. And as a consequence, we're in a position where we could agree the policy. That would be writ large. It would be really clear we sent that through. So I think you've got to be careful, in terms of that, and make sure when you are agreeing the policy, it's gone through the relevant structures in the union, whether it's gone through the relevant local structures. That might include discussing it with colleagues locally. And obviously, when we are looking to a policy, whether we don't agree it or not, we still do the hard yards, because we are always trying to reduce the detriments that might be in a policy towards our employers, our members. So even if we don't agree a policy, and I know Anne will talk about this a bit later on with disciplinary, even if we don't agree it, we've still changed it, and we've changed it for the better for our members. And I think it's important to give feedback to members around that. So you might want to have a sheet where you just bullet point what the key wins are, but also what the sticking points were. And as a consequence, the conclusion would be you didn't agree to policy. But you're showing that you've secured wins for our members because this was changed, however, this wasn't. Okay. I also think as well, and the reason why I said agreeing a policy is really important. Okay. I've certainly had this before where silence from us, no response from us, has been taken that we've agreed. I've certainly had that. And I think it's really important to say to them, us not responding or us staying silent on something, does not necessarily mean or should never be construed that we've agreed a policy or procedure on behalf of the union or behalf of our members. So I think it's really important to understand that, because employers will, and coming from a slightly cynical position here, employers will try to push it. They will try to chance their arm. And as we know, in life in general, there are good people, there are not so good people, there are less good people, and then we get to bad people and what they do. So, they are a reflection of the human life. They're a reflection of the different people, personalities. So you will get really good ones, and I've got some really good ones where I've got good policies in place. Even though we don't agree with them, we know they're good, and we know we're not going to end up having a problem. But I've got some employers where we've got really draconian policies. They're not good for our members. So we've got to be careful about this idea of silence meaning agreement, because it could come back to bite us. Next slide, please. Thank you. So this is just showing you what I mean by that. So as I said to you, I always send an email to an employer with the policy. Yeah. So this is not necessarily what I say, because I know it in my head and I know what I write, so I change it sometimes. But this is an example of what you might want to say. So the NASUWT has attached an annotated copy of blah, blah, blah policy with our comments. We believe that incorporation of these comments will strengthen the policy. The union looks forward to receiving a detailed response to the comments submitted, and following the end of the process, a copy of each final adopted policy. Please note that all our responses are sent without prejudice. Now, I did mention earlier on that I use the word meaningful consultation. So even on reflection, looking at this, what I would add to that middle paragraph is the union looks forward to receiving a detailed response to the comments submitted by the NASUWT as part of a meaningful consultation. So you can get it in there, because if you're saying that, if you've got an employer that comes back and doesn't say anything, then we're laying the trap, as it were, for pursuing that and taking it further, because we would be able to say quite clearly that wasn't meaningful. You haven't engaged in meaningful consultation. Right, next slide, please. So previous policies and no detriment. So this will depend on the situation. For example, a local authority school or academy. But one of the things we would like to always, and I always try to get this in any policy, and it's just a paragraph at the start of any policy, is just to say, those people who may have transferred to an employer on better terms and conditions, they will not suffer a detriment. So I always try and get it in there. Most employers recognize that, some less so, but most do, and most are happy to put a paragraph in. But it's about basically saying it's protecting us as an organisation, it's protecting you as a person consulting and negotiating these policies, because we're clearly saying, look, we don't know, because we may not understand and have information about these policies, but what we're saying is if there's a detriment, this covers it, because it says nobody will suffer a detriment if they're on a better policy that they transferred over. Now, one of the ways we can ensure that is by doing a mapping exercise, and we would like to think that employers do a mapping exercise. So if there are 3 local authorities and they've got disciplinary policies that they've inherited that are different because they've got schools in different local authorities, we would expect the employer to do a mapping exercise and do a rigorous exercise. And we would always say you should look to ensure that the better terms and conditions are the ones we settle on. Otherwise, members in this area, in this local authority, will be suffering a detriment. We couldn't then, with all good conscience, accept that, because why should they suffer a detriment? What you should do instead is level up and enhance the other colleagues' terms and conditions. Next slide, please. So consultation versus negotiation. So do check the wording in any chura or collective agreement, because there is a difference between the two, and obviously the bargaining power it gives you as representatives of the NASUWT. The word negotiation is by far stronger, because it basically says you've got to reach an agreement. So if you've got that in the policy, then it does mean they've got to agree it with you. And I've got a number of employers recently where they have tried to pull a fast one, and we've had to say to them, hold on this issue, it's negotiation, it isn't consultation. So you're consulting with us when actually you've got to reach an agreement with us. You cannot impose, because that's not what the word negotiation means. So consultation is, I'm letting you know, I'm consulting with you, you can respond, but we can choose not to agree. And that, as we said, go back to policies, can often be the case. But if you've got the word negotiation in there, it is stronger. It's about reaching an agreement. Okay. So they should not be confused. And the word negotiation is far stronger. So if you get that Natura and you've got it and it's around policies, etc., and you've got something in there about, well, the employer wants to reach an agreement, then we can use that to our advantage when dealing with policies and procedures. Next slide, please. And so again, just rounding off, important to establish timescales that enable meaningful consultation to occur. So as I said earlier on, I knew I'd do this. I'd talk about stuff earlier on that I need to talk about now. It is important to try and establish how many policies you're looking at. Is there a need for separate policy meetings? Ensuring a policy is received and ensuring a written response from the employer. You may find the use of track changes there. So one of the things I notice happening a lot more now is the use of things like SharePoint or Google Documents, where it's a live document. I think there's a note of caution there, because often it can interfere with this process. This process, to some, may seem quite antiquated. To me, it seems like it works. And I apologize, I'm a bit of a Luddite, because I know it works. And I know it works for me, because I know when I get emails from employers. Whereas sometimes, I've had this recently about a meeting agenda. I asked them for the agenda and their response was, oh, we've put it in SharePoint, or it's on the relevant section of the website we use. And of course, they've got out of they've got out of the system. And it's difficult because you're not always going to go in there and look at it. You're not going to go into an employer's website and look at the relevant section they've got set up for you. So I still think there's merit in having a system where you know when you've received something and you know when you've submitted something. I think that is important. Now, obviously, paying conditions will remain the same if you transfer to a new employer, because of the way that the transfer of undertakings, protection of employment regulations, or TUPE, works. But obviously for new employees, and this is where you can get a two-tier workforce to some degree, for new employees, they can be in a school on different terms and conditions. So again, we've got to monitor that. However, if you look at the majority of employers, I think the overwhelming majority of employers do still honour national pay and conditions documents, like the school teachers pay and conditions document. And the argument would be on that issue, if the school says it is going to go away from that, move away from it, you've got issues like some schools looking at teachers' pensions, then they have got to negotiate, because those are terms and conditions, and they're stronger than just consulting. It's a negotiation on that, because they're fundamental terms and conditions. And often that is insurers or trade union recognition agreements that we agree with employers. So I think that's the last slide from me. I think it's over to my colleague now, Anne, and I hope that was useful. Just go back, Anne, sorry. My apologies.
I'm just having a problem with my screen. Here we go. Could you just sorry.
Right, I don't know if I can do it.
Yeah, I'm having a problem turning back from that screen.
Okay. Well,
hold on. I think I've done it. Yeah, that's it.
Sorry. Yeah.
All right. Thank you.
It was just to round off, I think, what I'd said. So apologies for that. About can you work with others? I think we've always got to maintain the NASWT's position on things, because that's who we represent. That's what our members want. So, you know, together where we can, if we can, but obviously caution about collective responses which the employers could use against us. So I think there's again, this is important consideration when you look at working with others, you know, and collative responses. Collative responses is different to a staff side response, I think, because when you're collating responses, all you're doing is just saying, this is what Unison said, this is what GMB said, this is what NASUWT said, this is what NHT said. That's what you're doing. You will find, by the way, and it's certainly been my experience, I think Anne would agree with this, that some other trade unions are better than others at submitting comments. And again, it does depend on the individual in that trade union in different areas. I've definitely got geographical differences where some are really good and we work well together. Some where I would be ultra critical and say sometimes they are colluding with the employer. So I wouldn't want to be in a position of working with them. I keep my own counsel, but it's the same union, different individuals in different places. So it does depend. Yeah, one trust have got a really good, staff side secretariat. Again, we all do our comments and we all collect them, collate them, put them into the employer, and it works really well. Others, it doesn't, and basically we just do our own thing. So yeah, so those are again important considerations. So hopefully that's been helpful. And now over to my colleague Anne, who's going to talk to you about disciplinary procedures. Thank you.
Okay, right. Thanks for listening, and hopefully we'll have time to do a few questions at the end. Disciplinary policies, as I'm sure a lot of those of you that do casework know, it's a statutory policy for any employer, and it is one of the policies that's quite important for our members if they do have any issues. And I guess one of the reasons why it's so important is that for a teacher, if a disciplinary can really make it difficult for you to get another job, particularly anything to do with safeguarding. So it's sort of really important policy. And they are quite intimidating because, as Paul said the other day, I had one for 64 pages and really a lot of it was repetition. But I remember what I know what it's like when you come in and someone gives you a massive 64-page policy. So I kind of think, there are just points you can look out for that are important when you're going through it. Don't feel you have, obviously if you can read every word in detail, that's great. But if it's some key issues to look out for. So most disciplinary procedures have a couple of sort of stages, really. So you've got an investigation meeting, sharing of written allegations or terms of reference. I think this stage of the procedure is really important, and there aren't that many policies that say terms of reference, but it's quite useful because essentially what they have to do is put out the exact allegation that the member is having, that the member is being asked about. And I think too often meetings become a kind of fishing trip where they start asking questions that have got nothing to do with what the actual issue is. So there should be sort of terms of reference for the investigation. So, for example, we are investigating what happened on this day in this lesson. So the investigation meeting, I think it's really important from our point of view, because the investigation meeting is where you set the process off well, and you sort of, obviously you don't want to, a lot of members will sort of just start talking, thinking that by over explaining that they're helping themselves, when often they're actually not helping themselves, if we're brutally honest. So you've got the investigation stage, and if you can get really clear, like, what is the allegation? So if they start saying, oh well, a couple of years ago something similar happened, didn't it, you put a stop to that nonsense. The investigator should make a recommendation to the person that has commissioned the investigation. I often call it the commissioning officer, but people use different terms. So that investigator will make a recommendation whether there's a case to answer or there isn't a case to answer. That's as much as they should do, really, as part of their report. The next stage will be the hearing stage. and whether the hearing is for misconduct or gross misconduct. We tend to like to have clarity on whether the hearing is gross misconduct or misconduct, because if it's gross misconduct, it will go to a regional official for NASUWT, and so you can sort of send that over to the regional centre. And there should be a section about appeals. An appeal is obviously really important in any process. I'll just move that on. Another really important thing about disciplinary policies is representation. Obviously, we need to try to include that the employee should be allowed representation at all stages of the process. Now, obviously, in the law, formal representation is allowed. So as soon as you get to a hearing, they are obviously allowed a trade union rep. I think where there can sometimes be a grey area is the investigation meeting. It's really important that a rep can be at the investigation meeting, and most schools and trusts, local authorities agree that reps will be at the proper investigation meeting. Where it's a bit, if you can get that in the policy, that is really good. Where there's sometimes difficulty is the policy often allows for a sort of sometimes they call it a scoping discussion. So, for example, if an incident happens on the day, the head teacher will call the member in and say, what happened? In some ways, it is difficult to agree to represent, to sort of get representation for that meeting, because that might have just been something that happened on just a quick what happened here conversation. But members, obviously, the really important meeting is the formal investigation meeting. And of course, if something really serious has happened, hopefully members might have got on the phone to us, and it may be better for them to sort of wait for the proper investigation meeting. But certainly representation at every stage possible is important. And there's I'm sure you'll all know that under the ERA section 10, meetings can be postponed for 5 working days so that they can have trade union representation or a mutually agreed time. Well, I mean, it's usually within 5 days, but sometimes the employer will, that they won't be able to manage that either. If you are likely to be sending something over to the regional centre for a dismissal hearing, I'd suggest you don't agree that time with the employer, because obviously the regional official may not be able to do that time. Obviously, also be a bit wary about policies that ask you to agree a hearing meeting in the investigation meeting or at some other time. It's always best to wait for the full process before you agree to any meetings. So all disciplinary policies will have sanctions. A lot of disciplinary policies these days have what they call informal management advice, where the manager can have a word with the person about whatever the issue is. The only thing that is a bit of concern about this is there's a difference between a manager taking someone aside and say, look, don't do that again, or that conversation happening, it's going down in a note, the note is going on the file. Obviously, that's not something that you've been able to appeal in any way. That's just the opinion of the manager. If there is this informal sanction, it should certainly be noted in the policy how long it's going to stay on their file. It should be noted that it's not going to be used in a reference. And I just think there is a concern with these informal sanctions sometimes, because they can sort of mount up, if the member perhaps has a difficult relationship with their line manager, and it may be that they're not entirely fair. So I think it's difficult, because obviously on the whole, members are going to prefer to have an informal sanction than a formal one. So it's difficult to disagree with. But on the other hand, what you don't want is them to be used almost as a sort of, not exactly bullying, but, sort of lots of them being sort of being issued. And our sort of general advice is verbal warning, 3 months, written 6, final 12. I think it's always important to remember for teachers that if you say 6 months, it's always more than 6 months, isn't it? Because if you're looking for another job, you know, you'll be applying for jobs perhaps for the next term, and you'd still have that warning on your file. So, you know, that's quite important to try not to let it go above that. And a lot of policies include sort of reference to demotion and agreed warnings. And I'm not very keen on those, and particularly agreed warnings, because I think members get so upset sometimes they'll just agree to something just because they think it will make the situation go away, and that's not always a good idea. So again, demotion is difficult to sort of disagree with, because if someone's actually going to be sacked, you know, it might mean they could get another job. But on the other hand, that could probably happen anyway. I think with teachers, you know, yeah, I suppose, yeah, it's difficult. I'm not keen on those, but I can see that, you know, that the HR colleague will say, well, would you rather they would dismiss them? So it's a difficult one. I think roles and responsibilities are really important in the process, as I'm sure those of you that have done a lot of casework will know, because the member, you know, will not feel it's fair if it's the same people or someone that they know they've had issues with making the decisions. So I'm really focused on the scheme of delegation, that there should be a scheme of delegations, because there are some which is usually like a chart that says, you know, the head teacher does this meeting, the panel does that meeting. I think that's really important, because some policies just leave it really vague, and so it could be just anybody that they get in could be sitting on a panel or making a decision. I think the difficulty with multi-academy trusts is that on the whole, a lot of them have excluded governors from being involved in any of these decisions. So they're bringing in, you know, executive leaders. And, you know, I try to push that there should be someone who's not an employee of the trust, particularly for gross misconduct. But, you know, it is sort of up to them. But I think there should certainly be a panel if it's for a dismissal and for an appeal. There's usually someone appointed as an investigator. So, for example, the head teacher might ask the deputy head to do that role. Or, of course, they could get somebody from an external company. If it's a really complicated case, there's often external. They, of course, are supposed to be independent. The case should be commissioned by the disciplinary officer or the commissioning officer, which might be the head teacher, for example, or the executive head. Again, for a panel, I do think roles in hearings are very important, because in my view, in a hearing, you have the commissioning officer, or sorry, you have the panel, or the chair of the panel, the person that's hearing the case and making a decision. You have the member and the trade union rep, of course, and then you have a person that presents the management case. Now, in my opinion, I think the commissioning officer should present the management case, but sometimes the investigating officer presents it, and that's legal. What I think is sometimes difficult is when they suggest that both the commissioning officer and the investigating officer should present the case, and you almost get like a tag team of two, you know, the two senior members of staff, perhaps. And I think that's quite intimidating for the member. So I always try and get in the policy that one person presents the management case, and if they want to call in the investigating officer, for example, they call them as a witness. So I don't think it's very nice for the member if they've got two people sort of chipping in at whatever the you know, the incident was. And yes, I've said again, a lot of academies seem to be cutting out governors, which is a shame. Most of the policies involve timelines. So notice for meetings 5 to 10 days. Certainly for misconduct, it is better if it's 10 days, if possible, for gross misconduct, because you know, someone might get the notice on Friday at 4:30, and then they call us on Monday morning, and there's only a couple of days to get the paperwork together. They often give a deadline for submission of evidence, which I think should be, you know, 3 days notice, if there's 5 days notice and they're only giving you 3 days to submit evidence, that's just not enough, is it? So I think you need to get that as low as possible, preferably 10 days notice for the hearing. Often with the appeal, I think it's good to have 10 days notice for appeal, so members can get their evidence together for the window for appeal. Strangely enough, sometimes in policies, they sort of say the appeal will be done in 20 days, which seems to be kind of pushing it down the road a bit. But certainly those timelines are important. Here we go. And other key elements of a disciplinary policy, and I would advise you to look at our checklist as well, are things that I think are something just to bear in mind. Nowadays, it's always suggested that a trust or school should look at alternatives to suspension, and there's a case called Aguirre versus Lambeth, where I think the member was suspended for a very long time, which wasn't good for them. And so alternatives could be suspension, could be working from home, working in another school, doing some other kind of work. Obviously depend a bit on what the allegation is. There are often lists in policies of examples of misconduct and gross misconduct. Sometimes I think they're a bit subjective, like following reasonable instructions. I often change that to following reasonable contractual instructions, because obviously someone might think it's reasonable that the teacher works in their lunchtime, and they might, that's obviously outside your contract. I think notes are important, because often they send the notes of the investigation meeting and say, you need to sign and agree these. And if it's like 10 pages, I mean, when I first started, I used to go through and make all these changes in red and blue and all this kind of thing. And in the end, I discussed it with the regional official. And I think what you have to do with notes is, if it's something that's completely not right, you clearly have to point that out via email and say that is not correct. But what you can do is say, I understand this is the employer's record of the meeting, and we're not in agreement with it, but we take it as the employer's record, because it's their record. It's not your record. It's their record of the meeting. And I think it's quite, they don't like it when you do that. But as long as you put it in an email that we understand this is your record of the meeting, it's not agreed. I'd like to point out that something X was inaccurate. So I mean, that's my decision. If you've got time to go through every word and change everything, but it's important to make some kind of response, because obviously if you don't make any response, then they'll just assume it's agreed, as I think Paul just noted. I think safeguarding is obviously a massive issue for teachers. If there's something like really serious that's gone to the laddo, clearly on the whole, that stuff has to happen before it comes to disciplinary. And I think sometimes there's a rush to push these along. And I often say to members, members often think that by doing things quickly, that will actually result in a better outcome for them, which we all know is not the truth. Repent in leisure. So they do need to wait for that safeguarding stuff to happen. And obviously I'd take advice from the regional centre, but sometimes if it's a criminal matter, it may be that the whole thing has to wait. I have noticed in some policies them saying things like members will agree that their witness statements given to the police should also be used in the school, which I wouldn't agree to, because it's a different case, but you may not have much choice on that. I do think low-level concerns have become a real issue, and I'm really concerned about low-level concerns, because we all accept children need to be protected, but I'm sure you're aware that basically low-level concerns could also be gossip, that someone has said, oh, I've seen X doing Y, and there may not be any evidence for it. So I think if it's part of the disciplinary policy, there has to be clarity on, where that is recorded. Will it be used in references? Does the member have an opportunity to sort of come back on? I think the member should at least know there's a low-level concern about them, so they're aware of it. I think confidentiality is fairly obvious. Everyone is supposed to keep things confidential. There should be a paragraph about that in the policy. that, in terms of union representative, most disciplinary policies say if the union rep's under representation, that someone from the trade union official should be telephoned or contacted. We usually put at the end about an equality review, and I think it's quite useful to have a hearing procedure, because sometimes hearings aren't very well handled. At least if you have a procedure, everybody can work through who does what when. And I'm not a big fan of written statements. I think that is doing the employer's job for them. They can have a meeting with the member and do their own reports. I think having unless you're advised by the regional centre, I don't see that members should have to give in a written statement. And finally, it's useful that managers have some training. I see we're getting near to question time now, so I'll just move on. Some useful documents about disciplinary policies, and obviously wording is always important, like may or will. You may be subject to investigation, not you will be subject to investigation. And they often have flow charts, which depends if you like flow charts, really. And I guess time for questions. Paul, do you want to join now? And because
Yeah,
you can answer any questions as well.
Do you want to end the slide? And then
I think I'll stop sharing, shall I?
I've been trying the best I could, Anne, to answer some of the questions in the
okay.
As we've been going along, because I know you've been busy talking about lots of excellent things. So
Stop sharing.
one question I didn't answer was from I think it's from Leslie Lloyd. I've been told never to agree a policy as we only note them. Is this still the case? Well, I mean, my experience is that if it meets the requirements of our checklist, then we can agree a policy. I think it's rare because, as I said earlier on in my presentation, it's we have quite a high bar and quite a high threshold for what a good policy is. So it's a good question. I mean, if that's the position you take, Leslie, then I suppose that's the position the union would take if you are accredited to negotiate policies on our behalf. But I do think there are employers out there that are trying to do the right thing, and as such, there may be instances where we could agree a policy. I've certainly agreed some grievance policies in the past. I've agreed some flexible working policies, but the big hitters, if you want to describe them, like disciplinary, capability, pay, performance management, far less likely we've agreed them. Although I certainly have got some policies where I don't think we'd be in dispute. We just don't agree them because just don't quite get over the line. So I don't know what your view is, Anne.
I think one thing just to flag up is I think we're always quite careful about redundancy policies.
Yeah.
But I don't think I've ever agreed a redundancy policy, because clearly then at the end of the policy, a member might get dismissed. So, but
very good point. And that's my position always is couldn't agree a policy at the end of the day could make one of our members redundant.
I mean, obviously what we do with redundancy policy, just look at what the pay is, because that's one of the biggest things. Another thing is codes of conduct, because I think we always say, well, the code of conduct for teachers is a teacher standard. And I think often codes of conduct are just ways of putting in lots of sort of quite petty stuff about, wearing smart clothes and things like that. So we don't tend to agree codes of conduct, but it's not a specific rule.
One of the other questions is from an anonymous attendee. He comes to all my events. He's a very, very popular attendee, the anonymous attendee. So it says here, Anne, can a potential employer ask if a member has been subject to disciplinary action? Are spent sanctions no longer subject to any disclosure? Now, I don't know about you, Anne, but my experience of negotiating and consulting on disciplinary policies, I always make sure there's a part in the policy, if I can get it in there, where it says when sanctions are spent, they will no longer count and they will be discounted for purposes of a reference. So I always get that in there. I've got it in with quite a few employers. Obviously, I don't always succeed in that, but that would be my position. I suppose there might be an argument. It depends on what the issue is. But if it's a spent sanction, so if somebody's, say, for example, somebody's got a warning for or a sanction for, being continuously late, then obviously if they've improved that and the sanctions elapsed, e.g. it was 6 months, whatever, then obviously once the 6 months is gone, you can't keep it on file and hold it forever, because that basically just holding a stick over somebody's head to beat them with whenever you deem it appropriate to do so. So for me, when it's spent, and it shouldn't be disclosed, and that should be clearly in the policy. And the person can access their files to see if it is destroyed. Anne.
Yeah, I did. I was having a conversation about this recently, and I wonder if some employers, I think, like the person said that, I think some employers might be actually sending on the reference, has anyone been subject to an investigation, which I think it's not really appropriate. But I don't know, because I haven't actually seen it. But they shouldn't really do that. But they should only say if there is actually a warning. So it'd be interesting to see if what they put on the reference, form. But I don't know. I just kind of heard that as a rumor. And the other thing I wanted to point out is I do think this is another issue where low-level concerns are problematic, because often the policy says we won't mention a low-level concern unless it's about safeguarding. Well, most of them are about safeguarding, aren't they? So the difficulty is what, like, for example, a low-level concern could be a teacher being in a room on their own with a pupil. So, what if that happened and then you were told by the head teacher, don't do that, and then it never happened again? Is that enough to go on the reference or not? I suspect it's probably going to be quite subjective, isn't it? I mean, clearly I do think low-level concerns are problematic sometimes, because there may not be evidence of what they are, but I could go on about that for hours. But
I do think with keeping children safe in education, I do think there's a mismatch between what the department thinks should happen and what actually happens in reality. I think it's a good point, mate, because the reality is, as far as I'm aware, is they shouldn't be disclosed, and a school could be in breach of keeping children safe in education were it to do that. So, but I think, the reality is they do often, and it's a bit of a concern. I think certainly we continually raise these concerns with the department in terms of the way in which things are written, and then obviously subject to some level of interpretation. But hopefully that's answered the question to some degree. Keith, recent teacher regulation agency case ruled that management advice was a disciplinary sanction. This is problematic since it's potentially not time limited. I did start to write an answer here, Keith, because this is the concern I've got. When you sometimes get the more official sanctions, they are quite clearly time bound, and they're going to go, and after a while they might be destroyed, and they'll no longer be on a record, and no longer therefore be able to be referenced. I've seen employers sometimes use other lower level sanctions, and obviously our members tend to bite their hand off if it's a lower level sanction, but those sanctions aren't time bound. So in many ways, you'd argue it seems ridiculous, this, Keith, but you'd argue the member's better off taking a much better sanction, a harsher sanction, because it's time bound and it'd be removed. But lower sanctions aren't time bound, so they're never removed. I think this is where we've really got to make the case, Keith, and I continually make that case with my employers about that, because I do think it's problematic. All sanctions should have a time bound nature to them. They should be removed and they should be destroyed, because otherwise it is making members hostage to a situation, and it's keeping this stick over their head they can beat them with whenever they want for however long they want. That's not acceptable, because it could be, as we described, Keith, it could be a management advice, could be your timekeeping's poor. Well, if you improve your timekeeping, you've addressed the issue and you've remedied it. So why should that be held on file forever and ever and ever? And any manager, any new head in the school could see it as well. I don't think that's acceptable, but I recognise your point. It is potentially a problematic issue, yeah. Just looking at what else we've got. Keith also mentioned the case you said about the court overturned the original decision that suspension wasn't a neutral act for professionals such as teachers, but it gives us a list of things the employer must do before suspending the member. I mean, I think the dilemma you've got here is that in schools, depending on what the nature of the issue is, it might be the case that school says there are no other alternatives other than suspension. And if the member's going to be suspended on full pay, then obviously it might be the best course of action. Sorry, Anne.
After you, fine. Yeah, I just
And that's all I was going to say on it.
Yeah, I mean, sorry, Keith, I'll check that, Keith, because that but I think you know, the point is they're supposed to look at other issues. I have to say, I do think with teachers, once you get to that point where someone's decided to suspend them, there probably isn't going to be much other. I always think there's a danger of people going into those suspension meetings and having arguments about what they did, which then really giving the employer lots of evidence, you know, about what, you know. So I will check that, because if that's wrong, I need to change that. But I think now but I mean, I think the issue is they need to look at other things, and I think on the whole they do now. You know, they at least put it in the policy. Whether they actually do it when it comes down to it, I think is another matter. But you know, it would be interesting to know if, since that is more frequent in policies, whether there's been fewer suspensions. I know, you know, I remember in the past having people suspended for a long time over sort of fairly ridiculous things, frankly. But you know, that may have changed now. I think it may also have changed now we've got larger employers, because I suppose you could, as long as it wasn't a safeguarding issue, I suppose you could redeploy them. But that's a helpful point, Keith. I'll check that and I'll change the PowerPoint. So I'm sure you're right.
I suppose as well, Keith, there's an element of pragmatism on the ground when you're dealing with a case, because quite clearly the member could be told, well, we're going to move you to another location. We're not going to suspend you. We're going to move you to another school. It's a half an hour drive away. Well, does the member actually want that? Because that might actually cause them more stress, anxiety than potentially being suspended. I think it's important to understand that suspension isn't a neutral act. So employers can't infer from suspension one thing or another. Yeah, that's the key thing, isn't it? They can't assume that you've been judged because you've been suspended. Is the argument here? I just think, as I said, there's an element of pragmatism. Would I, if I was dealing with a case where I would want to understand what the member would want, and would the member necessarily want to be sent to another school, and all the questions that go with that in terms of, well, why has this teacher been sent to us? Why are they coming over here? I understand they work at this school. Why are they over here? So I don't know, Keith. I'm just floating that. I'm not saying I know the answer, because a lot of these things are far more nuanced. But yeah, it's a good point. Bernadette asked, does a member have the right to see the wording noted on a course of concern? They should have the right to see what's on there. I mean, they should have the right to access a personnel file. And if the employer's been all good about that, then the member can submit a subject access request. So why should it be hidden? Why should it not be anything different than what the member has agreed in terms of the sanction if they've admitted liability for what they've done? So there's no reason why there shouldn't be.
In fact, I think there's a school where a member had a lot of low-level concerns in his file that he wasn't told about, and regional official asked all the members to ask for their case for their own files, so that they could all see what they had, what was on their file. But I try and put in all the policies as a matter of courtesy. The members should have a copy of whatever's been written about them. Most people agree with that. I mean, it's where it's being done surreptitiously, there's probably a real problem.
And just one point I would make before we close. I know it's gone over the running time, and I think it relates to your presentation on disciplinaries, Anne. And it's just a tidbit from in terms of my experience, is when you get the investigating officer thinks they've been really clever and they've typed up all the witness statements, because I remember pushing back on an investigation hearing because I said, well, and I actually said to the investigating officer, and they weren't very pleased with me. I said, well, I've got no proof that that actually is the pupil statement and you haven't just typed that up yourself. I said, I want to see all the original copies of the statements. And basically it took them 2 weeks now to get all of them. They had to get the students in rooms, write their statements and all this sort of stuff. Because they basically just thrust this typed document in front of me. And I said, well, who's to say, you didn't sit there last night and type that yourself? Because I always look in a disciplinary policy to always say to them when they say, oh, copies of evidence, I always put in the word original, copies of the original evidence, because they sometimes think that sometimes it's out of, it's more cock up than conspiracy, if you want to put it in that way. They think they're doing right by the children and the pupils, so they just will type it up. But I would say to them, well, hold on, if an allegation has been made, you should be able to see the original transcript of the allegation, because if they just thrust something into you that's typed, unless it's been signed by the pupil, then obviously that maybe makes it slightly different. But I do think it's quite an interesting dynamic to consider. But I think we're over time, Tim. So I do appreciate you staying on. I hope your meeting goes well. I hope colleagues have found that useful and it was informative. I think in answer to one question, the questions will be coming, the slides will be coming to you following the meeting. So if don't hear or see any of you, which is highly unlikely, I suppose, then do have a very, very good Christmas. Have a good break when it comes. Thanks for all the work you do on behalf of the union, and take care and stay safe.
Thanks a lot, and have a good Christmas.